Employment Law Essentials for Entrepreneurs. We are delighted to have you all join us once again as we continue our exploration of this fascinating topic. And it's indeed wonderful to see familiar faces and new participants joining us today too. Yesterday, I saw a lot of questions coming up in the chat box from our young, enthusiastic entrepreneurs as well as the corporate lawyers who are present here. I'm expecting the same today too. We hope you all had a restful day and are ready to dive into another session of Conference 4.5 filled with valuable insights and discussions. So, today again, we have an exceptional lineup of speakers and panelists who bring a wealth of knowledge and practical insights to the table. So, without further delay, let's introduce our esteemed panelists for today's session. Our first speaker for today is none other than Mr. S. Abhishek Kirti, an associate in the dispute resolution and litigation practice at King's Tupp and Kasiva Advocates and Attorneys. He specializes in civil, corporate, and commercial law with a strong focus on contract management and complex dispute resolution. Known for his strategic approach and attention to detail, Kirti has built a reputation for delivering effective legal solutions in high stake matters. His analytical mindset and commitment to excellence make him a valuable voice on navigating legal disputes in today's dynamic business landscape. Next up, we have Advocate Kirti Tiwari, an independent legal practitioner at the High Court of Madhya Pradesh, known for her dynamic presence in legal and social spheres. She practices at the Shindwara District Court with a focus on criminal law, matrimonial disputes, and banking matters. A graduate of RTM Nagpur University, Advocate Tiwari is widely recognized for her integrity, strategic legal acumen, and client centered advocacy. Also, being the vice president of Jeho Foundation, beyond her legal work, Kirti has been a motivational speaker, a social worker, and a mother of two, recently honored with the Kalki Gaurav International Award. Featured by All India Radio, she continues to inspire through her dedication to justice, empowerment, and community leadership. Next up, we have none other than Ms. Kriti Singh, a skilled full stack developer based in Pune, Maharashtra, known for her innovative approach to software development. Passionate about coding, problem solving, and cybersecurity laws, she brings a dynamic mix of creativity and analytical thinking to her work. Often describing herself as a coding ninja, Ms. Singh has a strong track record of building efficient, high impact digital solutions across the development stack. A commitment to continuous learning and technical excellence positions her as a valuable voice in the evolving landscape of technology and innovation. Moving ahead, we have Senior Advocate Rahman Smita, the founder of Global Law Thinkers Society in Bangladesh and an assistant professor at KIIT School of Law, KIIT University, Bhubaneswar. With an LLM in international law, she specializes in international law, constitutional law, and human rights and has a strong record of academic research and publications. Senior Advocate Smita is deeply and a seasoned academician and legal practitioner. With over 11 years of combined experience in academia and civil litigation, Priyaji brings a strong foundation in legal practice and pedagogy. Professor Chaudhary spent 7 years in representing clients in complex civil matters before transitioning to academia, wherein she had spent the last 4 years teaching and mentoring future legal professionals. Her dual expertise in litigation and education makes her a valuable voice in bridging theory and practice within the legal field. We are grateful for all of your presence, panelists, and eagerly anticipate your valuable insights and contributions to today's conference. We would also like to inform all of you that the HR team is conducting polls in the chat box throughout the session to encourage active participation from all attendees. Now, I would like to request all our panelists and participants for today to kindly switch on the webcam before we proceed to commence today's conference. And do keep a notepad and pen handy as requested to note down anything important if you wish. Recordings will be uploaded on our YouTube channel post 17th of May, that is today, in 2 days. Now, moving ahead, I would like to request Moving ahead, I would like to invite Mr. S. Abhishek Kirti to share his perspectives with all of us. Thank you.
Thank you, Shravan, and thank you for having me today. It's an honor to be a part of this conference 4.5, and I extend my warm regard and welcoming to all the distinguished speakers, participants, and my co-speakers and the entrepreneurs. Before I begin, I would like to place on today's session that given the time constraints and the inherently vast nature of the employment laws and labor laws, I would like to cover every detail would require hours of discussion, perhaps every more than a single day it would take. So this discussion will not include any technical legal provisions, section references, or in-depth statutory interpretations. Instead, I will aim to provide a broad functional of understanding of which law would apply, when they will apply, and why compliance is with them is critical, both a legal and an entrepreneurial standpoint. Let's begin with a very key fact. A survey by National Sample Survey Office (NSSO) reveals that 58% of Indian workforce is self-employed and 99% of them are micro entrepreneurs and micro enterprises. This tells us two things. India is a nation of entrepreneurs, from local vendors to a digital innovators, from roadside vendors to a cutting-edge startup. The result, despite having a great ideas and hard work teams, many startups collapse under legal risk, employee disputes, or penalties simply because basic employment law were ignored and basic complaints were not taken into consideration. So I would like to cover on the topics which are as follows: importance of choosing the appropriate business and appropriate entity to minimize the liability and meet the regulatory needs, necessity for legal compliances before and after business formations for sustainable growth, various mandatory registrations under employment and other legislations, fundamentals of employment contracts to safeguard the organization interest and prevent financial or operational losses, and importance of labor law audits and due diligence during the growth stages. Why do we begin here? Because the structure you choose, either it is a sole proprietorship, partnership, or LLP, or a private limited, it directly affects your liability as an employer, your tax exposures, your registration requirements, and importantly, the employment laws that applies to you. Each structure has the legal consequences, especially if it is a private limited company. It is easier for fundraising and is governed by Companies Act. It also faces strict labor obligations but enjoys credibility and investment accesses. Even an LLP, operational flexibility with limited liability and is suitable for professional services but still requires compliances with various labor and welfare laws. The structure not only affects the taxations, liabilities, compliances, but also the fundraising ability and the long-term scalability. Making the right choice at the outset can prevent the costly transaction later. The quantum of your legal obligations changes with the structure you choose. So various mandatory employment registrations. Many believe that before compliances begins after incorporation. It's not that true. Legal responsibility starts once the moment you think of hiring, renting a space, or offering a product. Before starting, you need to select the appropriate structure. As I have told you earlier, choosing a structure is very important and crucial to attract the liabilities and to limit your liabilities. To get registered and get PAN registration, GST registration, and getting various initial registration under the various labor legislations such as Shops and Establishments Act. And after formation, your complaints keep on growing. It keep on grows. For example, you get engaged a lot of employees, and you have to be very careful with the employment contracts and other labor law legislations which mandates compulsory registration under the Employees Provident Funds Act and Employee State Insurance Act and other labor legislations. I like to say that compliance isn't a bureaucracy, it is your foundation for sustainable growth. A missed registration may not hurt today, but it can stop you funding tomorrow. Remember, it's about creating a sustainable business. Non compliance can lead to high level penalties, license suspensions, or even create a business closures. A proactive approach builds investors and employees a confidence. Simply to say, you'll have to be more vigilant and cautious and prevent your business rather than fighting a strong litigation. So there are various mandatory employment registrations under the Shops and Establishment Act. As you all know, the labor legislation is a welfare legislation for employees. Even it is coded in favor of employees. There are few exceptions that saves the employer also from overburdening. For example, there are a lot of to promote the ease of doing the business. There are a lot of schemes our Indian government has brought into. For example, if you get it registered yourself with the Startup India, since we are dealing with the topic of entrepreneurs, I'd like to bring a connection between the entrepreneurs and the startups. As you all know, a startup is an entity not less than 10 years. It should not take the turnover of uh, 10 more than 10 crores in a preceding financial year. So there are few certain criterias in which a company can bring under the name startups, and government are easing the facilities in order to avoid and to make the business owners and the entrepreneurs to conduct their business in an easy way and to promote the growth of their business and the entrepreneur journey. So focusing on the Shops and Establishments Act, the act is applicable to all commercial establishments, businesses, office, warehouse, theaters, hotels, eateries, amusement parks, and national wide. It is one of the important regulations that regulate required to be complied with for all the businesses. The act is designed to regulate the payment of wages, hours of work, leave, holidays, terms of service, and other conditions of people employed in the shops and other commercial establishments. Applies to all commercial spaces, offices, cafes, or co-working hubs, some educational institutions. Registration under the Shops and Establishments Act is mandatory to get it yourself registered under the Shops and Establishments Act. You have to submit an application in a prescribed form to the inspector of area within 30 days of starting any work in a shop or establishment. The application is to be submitted along with the prescribed fee, should contain the details of the employer, the name of the establishment, and such other particulars as may be prescribed. It is important that the registration certificate has to be prominently displayed at each and every establishment. The Labor Department of each state has the statutory authority for registration processes. But yet, in many states, there are still physical and manual procedure for filings. And the other mandatory registration which is required is under the Employment State Insurance Act. It is a social security scheme, as I have told you earlier, since it is a welfare legislation. offered by the government of India, and it's a self-financing scheme. Who is required to register under the employee state insurance scheme? Any business with 10 or more employees earning under 21,000 per month and 25,000 per month in case of differently abled, it they are mandated to register under the employee state insurance scheme. Then the mandatory registration is under the Employees Provident Fund Scheme, which we call it as EPF Act 1952. It says that any company having 20 or more employees is mandated to register under the Employment Provident Fund Scheme. In order to do ease the business and compliance for the entrepreneurs, the government of India has made a unified Shram Suvidha portal in the official portal of Ministry of Labour and Employment, with a single objective of single window access for registration of licensing, related services and establishments and other stakeholders. This is a very way forward in order to do the business very registration purposes in a very easy manner. The government has taken all initiatives and steps, and this is one of the example which they are doing it. Registration for EPFO and ES employment state insurance for new public company and one-person company has been stopped on Shram Suvidha portal from 15 to 2020. However, the above companies will have to comply with the provision of EPF Act and ESA Act when they cross the threshold limit of the employment under the respective acts. Even if they doesn't fall under the criteria, that is 20 or more employees, if a company is willing to enroll themselves under the Employees Provident Fund Scheme, they are welcome and they can register. This is apart from being a compulsory registration, this is a voluntary registration is also provided, considering the welfare of the laborers and employees. Apart from that, under the Startup India, if your startup business is registered under the Department of Promotion of Industries and Internal Trade, in order to reduce the burden and increase the ease of doing the business, the Ministry of Labour and Employment, initially for 3 years at the starting, and now they have expanded up to 5 years to give a self-certified compliances with respect to 9 labor laws. They are Building and Other Construction Workers, 1996 Act, the Interstate Migrant Workers, Payment of Gratuity, the Contract Laborers, and the EPF and ESA Act. This is a massive relief for founders. But remember, self-certification is still a responsibility, and it doesn't mean any exception or exemption. It just reduces the inspection. Responsibility remains with you. Misuse leads to penalties and also even to a blacklisting the companies. So apart from various initial registration, I would like to cover upon the employment contracts, essential parts of making an employment contracts. As you all know, in any business formation or any business transaction, contracts are backbone of any business relationships. It gives a clarity, fosters trust, and provide legal recourse, and it will be easy for adjudicating your rights and liabilities in future if you're preferring for any legal recourse. Contracts are not formalities. They are just a safety nets for you. For example, if an employee is developing a code during your employment, the IP must belong to the company, not to the individual. So you have to draft the contract in such a manner, protecting your right and protecting your assets. So early startups often skip formal contracts with hire or co-founders think we trust each other. But when things go wrong, a written contract is what protects you, not an handshake. Startup that begins with informal relationships often suffers when dispute arises over the roles, equity, or intellectual property, even a labor dispute. This avoids emotional and financial fallout later. Every entrepreneur must implement employment contracts that clearly defines your job roles, specify your remunerations, working hours, and reporting lines, including IP assignment clauses, confidentialities, obligations, prevent solicitations, or competition through restrictive clauses. So basically, in an employment agreement, there are many things to be taken into a consideration. Essentially, whether you are building an employer-employee relationship, or it is a contract of employment for services or contract for employment of services. There is a major difference between a contract for employment or services and contract of employment of employment for services. To say contract of employment of services is like a master servant relationship. You will have a master servant relationship. Is how it is determined is what is to be done is to be told by the employer, and even uh, all detailed thing is also to be told by the employer to the employee. Whereas contract for services or contract for employment or services means it's like you are entering into an agreement or a contract with an independent contractor, where you'll have to independent contractor is typically an employer having a relationship working in your organization. So basically, when you are entering into an agreement with respect to the employment contract, you will have to be keen on whose responsibility is to pay the contribution, EPF contribution, and also the employee state insurance contribution. And it is to be clearly defined in the agreement, saying that no employer-employee relationship is there. But law also specifies even if there any dispute arises, the principal employer can also be made liable, and it can be made to be paid to the delinquent employee or the workman. And later, the principal employee can get it retrieved from the independent contractor. So it is very essential in drafting a contract or employment contract or agreement. Apart from that, you'll have to be very clear on the secondment clauses when you are entering into an agreement, specifically the employment agreement. So I would like to stress upon the importance of the labor law audits and legal due diligences. It's like how a person, they should be doing a regular health checkups and keep their health. As you say, health is wealth. Likewise, even in a business, you'll have to do a regular audit and a legal, which is like a legal health checkup, and it helps to detect you the gaps in provident fund schemes with respect to employee state insurances and to the bonus and leave payments. Why we conduct them? It ensures timely PF, ESI, bonus, and gratuity payments. It helps you to avoid penalties, legal actions, to protect you from future lawsuits, penalties, and it also builds investors' confidence and promote transparency and trust, and also a healthy business to run. Where do most startups get wrong? They lack you should be aware of your rights, so that no, in law we say ignorance is not an excuse in law. You should be aware of your rights and liabilities, and what are the incentives available in the laws. Any delayed registrations is uh, is is what a mini startup, I consider it as a where a startup is lagging. And no formal contracts, ignoring of mandatory policies like POSH, improper employee classification. The classification of employee, there is a major difference between the employee and a workman, and sometimes it is used in an interchangeable manner. So classifying your employee in an agreement, employment agreement, is very essential. And when you're starting a business, main thing is to be considered is you have to keep a playbook and HR policies and form a legal team. So how can you fix this? You have to use a compliance calendar by creating a compliance checklist tailored to your business. You can use, as an advent of AI, there are a lot of other legal tools to enhance your compliances. And you can conduct a quarterly internal audits, train your founding team on basic employer law and labor laws responsibilities and liabilities. You can hire, as I have told you earlier, hire a legal or HR advisor early.
Yeah, excuse me, Abhishek. Can you please wrap it up in 2 minutes? We have
Yes,
five more panelists today. Sure.
sure. So concluding, employment law is not a bureaucratic hurdle. It's just a strategic enabler. It helps attract and retain talents, ensure operational stabilities, and build trust with stakeholders. The startup Indian ecosystem offers great flexibility, but only if you use it in a responsible and a proper manner. As an entrepreneur, you're building not just a company, but a legacy. Let legal clarity be a part of your foundation. Wishing you all the very best in your entrepreneurial journey. Thank you. Thank you for the opportunity.
Sure. Thank you for the amazing speech, Abhishek ji. I request you
Thank
if
you
you
so
could
much.
just please share your email ID in the chat box so that if our audience has any queries, they can straight away reach out to you.
Sure, sure. I'll do that.
Sure. Now, moving ahead, I would like to invite Ms. Kriti Singh, a corporate lawyer with a strong foundation in commercial law, M&A, and private equity, and a graduate of the NLIU Bhopal batch 2016 to 2021. She has previously worked with top tier law firms like Cyril Amarchand Mangaldas and Trilegal, wherein she has advised a diverse clientele on complex transactions and regulatory matters. Known for an analytical rigor and solution oriented approach, Kriti brings a blend of deep legal expertise and practical insights to every matter. Thank you, Kriti.
Thank you so much. Hello, everyone. Thank you so much for taking out your time and joining in for the session. I think there has been a confusion. So, since 4 years, I've been working with the law firms, which is Trilegal and Cyril Amarchand Mangaldas, and my core practice area has been labor and employment laws. So, like it's the conference that we are about into. It's the main practice area that I had been working for so long. So, taking forward the session, I would take the aspects that Abhishek had covered. So, Abhishek had generally covered what licenses should a startup take and what essentials have to be kept in mind while getting into an agreement. While now I will dive into, as per these laws, what are the things that you should keep in mind for you as an employer and what you have to provide for the employees who will be working for you. As Abhishek discussed, that every startup or every company should take a registration under Shops and Establishment Act, unless of course it's a factory or an industry. So of course you have to take a Shops and Establishment registration, but what is this Shops and Establishment Act? First we should question about that. So this act is basically something which sets out the working conditions of the employees and what all are the obligations of an employer. So even if you and like it's a very important point to be noted, across the state we have, like, each state would have their own shops and establishment registration, and this act applies majorly to every company irrespective of the threshold or the headcount. There are few states, for example, I think in Maharashtra, the Maharashtra Shop Establishment Act applies only when you have 10 or more employees. But if you have even less than that, you have to give an intimation to the authority. So even if you have one employee, you have to comply with the act. Now, what does this act entails? It provides for the leave entitlements, the working hours. If you have to like terminate an employee, what are the conditions? You have to give them 1 month notice, provided if they have served you for 6 or more months. So every state Shops and Establishment Act would more or less have the similar things, but will come with slight variation. Like, I am sitting in Bangalore, so I'll take an example from Karnataka Shops and Establishment Act. So Karnataka Shops and Establishment Act says that every employee shall get 1 day of earned leave for every 20 days worked. So in total, in a year, every employee is entitled for 18 days of earned leave. So this is there under Karnataka Shop Establishment Act. This could be different under Delhi Shops Act. Delhi Shops says that 15 days of earned leave. But more or less, the major working condition, which is like working hours, rest intervals, spread over, your leaves will be there for each state. This is what we have to comply with. This was about Shops and Establishment Act. Now moving to EPF. EPF and ESI Act, what are these? These are basically social security benefits that every employee is entitled to. Every employee, as in there are certain threshold also who are eligible, unless EPF says that it protects only the category who earn monthly basic of 15,000 or less. But otherwise also, any employees earning more than that are also entitled, but there are certain criteria. There are like calculation thing which I have seen in my 4 years of experience. It has been largely misunderstood across every company calculates EPF on 12% basic of the employee's salary. But it's very important to understand that, and if you have pen and paper, I would just highly request you to keep a note of it, that there is a 2019 Supreme Court judgment, which is Swami Vivekanand judgment. It said that if in your if in your salary structure there are other components which are fixed in nature, which means that it's not subjected to any reimbursement or contingency, all those other components also have to be taken into account to calculate your PF. This is largely applicable to employees who are under the eligibility criteria, which is earning 15,000 or less than that. Employees who are earning monthly basic more than 15,000, if you calculate on 12% basic, that's absolutely fine. I hope everything is clear on that. If yes, can you guys give me a thumbs up if that's available on Google Chat, Google Meet? Great, thank you. Now moving on to gratuity. Gratuity Act. Now, what is gratuity? We have to understand the concept. Gratuity is basically a company honoring you for your long service. Gratuity applies to you when you have served a company for 5 or more years. And this also, the calculation of gratuity also goes hand in hand with EPF. So there are judgment which says that the calculation of gratuity should be pari materia with the EPF Act. And industry practice is basically gratuity is also calculated on basic salary, but it should also be calculated in the same manner as EPF. That is about gratuity. And of course, like, you are eligible to gratuity, but there are certain circumstances where the 5-year period would not apply. For example, in case of death of an employee. And an employer has also the right to forfeit the gratuity of an employee, provided if the employee has been involved in some grave misconduct and or have been involved in offense relating to moral turpitude. These are the conditions where an employee may be in a position to forfeit their gratuity, or and the employer can forfeit the gratuity. But of course, these are things that I am just basically touching upon. These are very vast topic. These require a lot of research. This is just, I'm giving you a guidance, like a clarity on the concept. And if there is like, if you need any help, of course, a proper legal advice is what you should seek for. Then there also comes ESI, as Abhishek has already covered. I think I'm not required to go into that. It's what he has covered. Then there is also Minimum Wages Act and Bonus Act. Bonus Act is also applicable to individuals, eligible to individuals who are earning around 20,000 of monthly salary. So they are entitled to around 8.33% of the company share. Like, it's a statutory bonus that they have to pay. They are entitled to. Okay. Otherwise, this is basically for blue collared employees. As most of us, not most of us actually, like most of the working population is blue collared employees, so they are entitled to statutory bonus. Otherwise, what we generally see that our friends just talk about, they are getting 2 lakh, 3 lakh of bonus. This is not statutory bonus. This is just as a part of their CTC. They are not entitled to it. And if a company places any restrictions, any limitations, that is absolutely fine. We cannot just say that, oh, it's my right to, in my CTC it mentions that I'm entitled to 3 lakh of bonus, 5 lakh of bonus, but you have not given me that. That's not your entitlement. That's just a company policy. Entitlement is what applies to employees who are earning up to 21,000. I hope we are clear on this. So these were the working conditions that an employer, to protect their business, even if you're a startup employer or an entrepreneur, you will definitely have people working for you. So these are the things which you also have to ensure with respect to compliance towards your employees. It will protect your business interest, and of course it will ensure that minimum statutory obligations or entitlements are met for the employees. Now I will move ahead with another very important aspect which comes to the company policies. And I will not dive into the customary policies, but I will dive into the statutory policies that are mandated by law. One is maternity benefits, second is POSH, which is sexual harassment, third is disability law or discrimination laws. So let's start with maternity. Now, what do we understand from maternity benefit? Maternity benefit is basically, it is eligible for women who are conceiving a child. And there has been a recent amendment in 2017 wherein a lot of other very favorable benefits have been introduced which were not there earlier. But like, what is the criteria? So if I'm a startup employer and a person, a female employee joins my company, and within 10 days she wants to go for her maternity leave. So, what am I supposed to do as an employer? Shall I just give her the maternity leave? Because maternity leave for like first two children are 26 weeks. It is completely paid. And if and for like more than two surviving children, it's 12 weeks. So this is not the scene. If like, there are eligibility criteria that a woman has to complete, which is she has to be on service on roll for 18 day sorry 80 days. Only then she can claim the maternity benefits. And maternity benefits, it's like available on Google. You can like simply go. I'll just quickly take a touch base on that. For 1 to 2 children, a female is entitled to 26 weeks of paid maternity leave. For more than two surviving children, it's 12 weeks. Then there are also provisions for women to avail the maternity leaves or maternity benefit if she's had a medical termination of pregnancy, if she's suffering from illness arising out of pregnancy, if a female employee is adopting a child, then she'll be acting as a commissioning mother, then also she's entitled to maternity benefits. Now moving on to very important aspect which is known as the POSH Act, which is Prevention of Sexual Harassment at Workplace. This is a very sensitive topic, but it is the most important topic. I think it has been important ever since, but thankfully due to Vishaka judgment, our laws have become very strong. So I will quickly touch upon, because I know there are other speakers also who have to cover their bit. POSH Act, under the law, only a women is protected against sexual harassment at workplace. Now, if we talk about workplace, generally in common parlance, what we have always been thinking is workplace comprises of the office where I'm going. But is it only limited to that? Would that thing give liberty to a person that if I'm going to attend an official event and if I'm sexually harassed, I can raise a complaint because, oh, the workplace is only the office? That is not the case. The workplace has an extended definition. Any place which is incidental or related to your work, which can be your official event, which could be your official travel also. So if my company is providing me a transport service, that will also be considered as a workplace. Since COVID times, as we all were working virtually, there have been high court judgments. What I can like currently think of is the Rajasthan High Court judgment, which extended the definition of workplace to virtual setup as well. So this is what workplace is. Now, who is an employee under POSH Act? This definition amongst all the labor laws, which are generally restricted, employee definition in POSH Act is extremely wide. It covers even the visitors, even the housekeeping staff, even the people who are not on your payroll would also be considered as employees. Generally, what a bigger approach and a nicer approach is that a lot of companies we have seen are adopting gender neutral POSH policy. So it's a zero tolerance sexual harassment against both the genders, against all genders. And there are specific timelines which has to be followed according to the act. Due process has to be followed, of course, because just because a person has raised a sexual harassment complaint, we cannot just say that, oh, the other person would be guilty. A proper procedure has to be followed. Then coming to, like, this is what I have recently experienced and seen a lot of people, like even the HRs in a lot of companies, while they deal with the posh investigation and act, and while they address, say suppose the company, they take training on posh, but I've seen that they are not very well versed. So there are they're very nuanced situations where things could be sexual harassment, but you never know. So I feel that everybody must be aware. Like, giving a very casual example, if I am on a virtual setup with you, say suppose I was wearing a t-shirt which had some logos, or which had some content which is very not acceptable, which could be vulgar. So generally a person would think that's not sexual harassment, but let me tell you, that is sexual harassment. Any place, any action which puts you in an uncomfortable situation, that would be counted as sexual harassment. It is not objective, it is very, very subjective. I would like to stress upon it as much as I can. Sexual harassment is very subjective. We have seen situations where, say suppose a girl is nicely dressed up and she is just passing through a corridor in an office, and there are a group of bunch of people or men, or say vice versa gender also, and they say, oh, she's dressed so nicely because she wants to catch on somebody. That is also sexual harassment. So we have to be, the starting step is we ourselves, we have to be very mindful of our actions, of the words that we use, and to make the place a safe working workplace. This is about POSH Act. Now, I'll just quickly take 2 minutes on the discrimination laws. So, in India, mandatorily, there are three discrimination law. One is the HIV Act, the other is Transgender People Act, and the third one is the Disability Act. So, generally, under the law, it's mandated that an employer who has reached 20 or more employees has to draft an equal opportunity policy. Now, what is equal opportunity policy? It means that you have to make your place a diverse working culture. You cannot discriminate basis on gender, race, caste, sex, creed, whatever. You have to give everybody equal opportunity. Now, coming with respect to disabled person, you have to have some provisions for them. There should be accessibility. If it's digital working place, you have to think of ways how you can make your, say suppose your software, your hardware accessible to them. Infrastructure has to be accessible to them. You always have to appoint a licensing officer, because if somebody has faced any discrimination as per their disabilities, so they have to have a resort to reach out to somebody. Same applies with person with, like, person who have HIV, AIDS or something, or who are transgender. So there has to be a person, like, you have to have a grievance redressal committee so that they can reach out to somebody if they are facing any discrimination. And everything, be it posh, be it this discrimination policies that I've talked about, things have to be kept confidential. I think that's about my time. If you have any question, please reach out to me. I'll just post my email ID over here. If you have any other doubts also, you can reach out to me, and I'll try to, like, get back to you as soon as possible. Thank you so much,
Sure.
everyone, for being patient, and I hope you liked the session and it was informative.
Thank you for the wonderful speech, Kriti, and especially the part about the Porsche one, because as Vanilla ji just said, it's one of the most frequently happening
Exactly.
litigations in India.
Yeah.
We mostly hear of Porsche cases whenever it comes to corporates more than any other operation or related
Yeah.
litigations. So
Yeah.
thank you for your speech,
Thank
and
you,
please do
thank
share your
you.
email ID in the chat box,
Yes,
since we have
definitely.
a small constraint of time.
Yeah,
If
yeah.
any of the
Please
audience
go
wants
ahead.
to
Thank you.
discuss any queries, they can directly reach out.
Yes.
Thank you a lot. Sure. Now, moving ahead, I would like to invite Advocate Rauman Smita from Global Law Thinkers Society, Bangladesh, to commence his speech and share his insights with all of us.
Thank you so much. Am I audible? I'm just checking my mic and everything. All is okay. Okay, thank you so much. I'm so glad to see everyone. Happy evening, everyone. I'm Rauman Smita, a Supreme Court lawyer from Bangladesh, founder of Global Law Thinker Society, and CEO of EcoCash Global Trade Hub. So today's session is about a vital shift in how we work and hire. I'm directly going to my session because here actually it's outside. It's storm is going on, so I will keep it very short but very specific and important for the entrepreneurs, as I know that all the audiences are from entrepreneurs and they're with their ventures and startups. So my topic will be helpful for you all. So we are in the age of digital first businesses. We are online now, and all our works are based on online, and freelancing have rapidly increased. Entrepreneurs are hiring global teams more than ever, but many are unaware of the legal risk involved. So today, my session is called Remote Hiring and Real Risk. It's like a very short term, like remote hiring. It's about hiring when we start our new venture, we plan a program. Nowadays, we try to work alone, and sometimes we try to make a team, but that doesn't work well. So, this topic is very important to hire your team and what are the risks and how actually you can build a very good team and get the best work from them. So I took this topic because most entrepreneurs ignore this part, like when you hire from remote. And really, I have seen from my experience, my legal experience, that how much they suffer after they ignore this kind of legal risks. So you see, while hiring remotely is easier than ever, like now anyone can hire from remotely. You just post the vacancy and people apply and you hire. But the way it shows very easy, it is not legally. In case of legal perspective, sometimes we really suffer big. So staying legally compliant is critical and often overlooked. So this is my topic today. Again, I'm saying it again and again so you guys can really focus in this important part, that how you can hire remotely, keeping low risk, or rather, I will say that to keep it very safe when you start your venture. So why it matter? After the pandemic, especially when everything became online, businesses are hiring virtual assistants, freelancers, and cross-border consultants. And then, but legal rules haven't vanished. Like even if you are hiring from remote places, but that doesn't mean that there is no legal rules for them. Rather, it is very visible and very important. So, misclassifying a contractor as an employee can lead to back pay, penalties, and lawsuits. This is a reality even for small startups. So now you know what I'm going to talk about. It is about the differences between contractor and employees. So let's talk about who is actually employee and contractor. Generally, we know sometimes we mix this employee and contractor. So let's know the differences between employee and contractor. An employee is under your control. They follow your schedule, use your tools, and report to you. And they are entitled to benefits, leave, and tax protections. So a contractor, other hand, works independently. You pay for the service, not the process. It's like how this contractor is going to give you the services, the process behind. You do not need to know about that. Rather, you're just giving that service as a contract. So this contractor actually decide when, where, and how to work. So if you treat a contractor like an employee without the paperwork and benefits, it's actually illegal. So let's see how it works, why it is illegal. Like you are hiring a contractor, an employee, whatever it is, how it can become illegal. That can be a question. But let's know about the laws here. So governments like in US, UK, EU, India, Bangladesh, and many other jurisdictions, they define clear differences between an employee and an independent contractor. If you treat a contractor like an employee, like controlling how, like in case of employee, you are controlling how, when, and where they work. Without giving them employee rights, you are violating labor laws. So if you are using or you are hiring contractor, but actually you are behaving like employee, then you are violating the labor laws, and it's same in case of employee, vice versa. So government, when they audits, they don't care about your intentions. They only care about definitions, like the law is written. So it's like you have to be very careful and differentiate about hiring in case of contractor and employee. So let's see about the government penalties and audits. As I told you, that what happens if you do not do the differences, then what happens in case of penalties or audits. So in case of tax authorities, such as IRS in the US, then HMRC in the UK, in Bangladesh, there is NBR, Income Tax Department, and EPFO in India. This audit, these tax authorities audit businesses to ensure proper classification. If they find misclassification, the businesses can be forced to pay back taxes, employees' benefits, fines, and even face lawsuits. So these are the basic scenarios that if you cannot differentiate between the contractor employees, so how it is going to happen. Because the contractor and employee, they can really complain, or they can, you can face really legal consequences for this. So let's see about remote hiring across borders. Like you are hiring from your country remotely, and you can also hire across borders. As now everything is online, and we are getting freelancers, so it is very important. So if your developer, for an example, if your developer is in the Philippines, or your assistant is in Nigeria, suppose, you still need to consider their labor laws. Like from wherever you are hiring them, you have to consider their labor laws as well. So avoid informal deals, use proper contracts, consider legal platforms. I'm just suggesting some platforms, you can check others. So far I know good that have very good report online. Those are like Deal, remote.com, or Upworks, Enterprise model for safety. So you can check all this, and you can hire from there. Then the contract part, as I told you, even though if you have small startup, or it's a big venture, whatever it is, always consider the contract, and always consider which clauses you are putting into that contract, because this will keep your venture safe, your business safe. So even freelancer needs solid contracts. In case of that, if you have to include some clauses, those are very important. I'm not telling the detail, but I'm just telling you the basics, like project scope and delivery dates, then the payment terms, and the currency, then confidentiality and IP transfer, then the jurisdiction for dispute resolution. Sometimes we do not think about it, that when we give the task, maybe there will be no problem, but it is always like problem is there. So why not you prepare yourself for that? If there is no problem, then that's great. But what if there is problem? So always put this kind of clauses, like the jurisdiction for dispute resolutions. I will also give you a handout after this session so you guys can get it in your hand and check later on. I'm just telling you the very basic things. So, as I was telling, these basic contract clauses, if you skip, then you risk losing your time, money, or data. You keep it in your mind that it is very much important that you keep these specific four clauses in your contract when you hire any kind of employee. Let's now talk about tax and payroll compliances. So track every payment. Whatever payment is going on, you keep a track a regular basis. Save invoices. Always remember, save the invoices. It is very important. If you have the papers, then you are really, really saved, because sometimes we can ignore whatever we are saying, but if paper is there, then you're safe already. So clarify if you are withholding tax or not. Then use for this, like tax and payroll, you can use some tools like Pioneer. There is Wise, there is Gusto or remote.com to manage your payouts and taxes properly. And a paper trail is your protection. Okay, so if there is no record, then no defense in court. Like if any kind of problem arises, then if you do not have the track and you don't have the paper, then you cannot file your defense. So remember and be very cautious to keep your paper. Then there is some real mistakes you must have to avoid when you are starting your business, or even any part of your business at any time. Okay, so I give you one example. You know about Uber. So Uber misclassified drivers and paid millions in legal fines. Like they actually misclassified some drivers, and they had to pay penalties. So this case you can find on Google. They really had to face this backlash in case of hiring, and how they misclassified their employees and the contractor as the drivers. So a startup, I advised, like lost an entire database because they did not have a signed NDA. I hope you know about NDA. NDA is non-disclosure agreement. So, like a startup can lost entire database because they did not have signed only NDA with their freelancer. This is also a case study I'm sharing with you. So hiring without legal steps is not agility, it's a risk you can't afford. So be careful always keeping the paperwork and also NDA, the non-disclosure agreement. Very careful about the contracts you make with your employees or contractors or whoever you are hiring to serve your services. So there is some tips. In 1 minute, I will share some smart hiring tips. Always use written contracts, no verbal contracts, not on WhatsApp, not on email, not on Facebook, on social media. You're just telling and hiring somebody. Do not do that. Always use a proper written contract. Then use digital tools for onboarding and record keeping. Then consult legal support before hiring across borders. If you have the opportunity, you can consult with your lawyers or who have legal knowledge. You can consult with them about this cross-border hiring. Then don't assume small teams don't need structure. This is the biggest mistakes entrepreneurs always does. That's they don't they think that we have a very small team and maybe we do not need any structure. But from the beginning, entrepreneurs should keep or make a very good structure for their venture. So here I go. Your business is global. Remember, nowadays, wherever you are, even you see, I'm from Bangladesh, but now I'm speaking, and from around the world, people are listening. So even if it is small scale business, think global. Your compliance also should be global. You think from the beginning about the global issues. Then build team the smart way. As I told you, I give you the small tips. You will also get your handouts. You can check on there. So where people feel secure and your operations are legally protected, if you follow the whatever I have suggested today. So thank you so much for being part of this session, and let's lead responsibility and grow sustainably. And if you have any question or if you want to connect with me, I also give free legal advices through my website and on social media like Instagram, LinkedIn, Facebook. If you search my name, Rauman Smita, you can find me and you can say me hello. And if you need any kind of legal support, let me know. So thank you so much. That's all for today.
Thank you, Ms. Smita, for coming from Bangladesh and representing your country on this panel, firstly. And secondly, thank you for letting us understand how the remote workplace policy is bringing a lot of shifts, because that is what we have been observing for the last 3-4 years after COVID came around. And now I think, as our audience is predicting, 99% of corporates do remote hiring. So thank you for the wonderful advice, and it's a pleasure to meet you. Please do share your email in the chat box so that if anyone has queries, they can directly connect with you. Sure. Now, I would like to thank Ms. Rauman Smita for her amazing, wonderful, and intellectual speech. And moving ahead, I would like to invite Mr. Minabai Sebofa to commence his speech and share his insights with all of us.
Thank you very much. I really appreciate the opportunity to be here. I hope you can hear me. Everyone can hear me. So it's a great opportunity to be here, and I'm excited to share with you. And I want to say kudos to the previous speakers and to the last speaker as well. It's been pretty insightful and very, very important that as entrepreneurs, we need to take an understanding and have an understanding of the laws concerning labor in a different context, whether you are employing online, whether you are employing offline. It's a very interesting one, and I'm really grateful for the opportunity to be here. Okay, you've called my name. My name is Minabai Sebofa, but I just want to make a little clarification, all right? I was the Director of International Relations at Divine Design Studio, USA, where I managed the international relations activities, or where I served as the buffer between America and African countries. So when I was invited for this program, it gave me that, that's very interesting platform to say, okay, I've got the experience with working with international companies and other African countries. So I'll be able to share one or two things here, especially from the Nigerian context. And like the last speaker said, even if you're employing online, you should understand the labor laws guiding the nations that you are employing from, offline, online, anywhere. So this morning or this afternoon from Nigeria here, I will be speaking from the business protocol point of view. I am the Chief of Protocol, Shieldfield Protocol Consultants Limited here in Nigeria, Abuja, the capital city of Nigeria. All right, so we are much more looking at the business protocol angle of entrepreneurs. So if you're coming into Nigeria to do business, we help you solidify your understanding of the business practices, of the business protocol associated with doing business in Nigeria. And this typically falls within our conversation today, employment law essentials for business owners. And it is important to know that a structure, dignity, and professionalism are really important to meet the realities of an entrepreneur. The last speaker also mentioned that whether you're a small business or a big business, the need for structure is paramount, is very important. And therefore, if you want to conduct business, your structure needs to be in place. And where structure, dignity, and professionals meet the realities of business and entrepreneurship, we are talking about it from the business protocol point of view. I want to make this statement. It's very important. I made a post just shortly before now, and in that post, you will see I mentioned Meta, the parent company of Facebook and Instagram and WhatsApp, were fined $220 million, $220 million by an agency in Nigeria called the Federal Consumer Protection Agency, the Federal Consumer Competition Protection Agency, and an agency responsible for guiding, for taking complaints from customers, from users, from people who make use of a product in Nigeria. And that particular case has made Facebook or Meta to threaten that they will be leaving the country because to them, the fine is too humongous. But you want to look at it. This is not the first time Facebook has been fined. This is not just only in Nigeria. It has been fined in other countries across the world as well for what these agencies called data breaches, data privacy issues. But when these things happen, you want to ask yourself, didn't they understand the essential employment laws in Nigeria? Not just employment laws, but carrying out business in Nigeria. Did they not understand the data privacy protection laws in Nigeria? These are law essentials, all right? These are essentials for entrepreneurs. So as we go further, I would like to share a few things. Entrepreneurship thrives on opportunity, but sustains itself on protocol. And it's important to know that employment without structure is not growth. Employment without structure is not growth. It is chaos waiting to happen. So whether you think you are a small company, whether you think you're not ready to go big and you don't put structure, it is only a matter of time before chaos comes into it. And when the government comes with their government policies and laws, you will find yourself to be blamed. I wasn't a big company. I'm not a big company, but you have flouted the laws. All right. So it's important for us to understand that as well. So let us understand some of the employment laws in Nigeria. Of course, it's important to know that today in Nigeria, the Labor Act and the Employee Compensation Act, the Pensions Reform Act, and other acts are the laws guiding employment in Nigeria. All right, let me just do a little bit of explanation into some of these laws. Just briefly. So what the Labor Act does is that it helps employers understand that written contracts are very important. It also tells us about the minimum wage. It also tells us about the pensions obligation. And it also helps us to classify workers properly. The last speaker also mentioned it. So I believe most of the conversations that we'll be talking about here today will be seeing one from the other and one from the other, since we're talking about employment laws. So the Labor Act deals with issues of contract, and it's expected that contracts should be written and not on email, not on WhatsApp, and not on all these other platforms. So for entrepreneurs coming to do business in Nigeria, one of the protocol with the Labor Act says, of course, you should have written contract as required under the Labor Act, and of course, classify workers properly. Of course, employee versus contractor versus intern. Right? Some organizations would want to use interns as employees, and some other organizations will want to use contractors as employees. All of these terms, all of these classifications they come with different responsibilities and different actions according to the law. So you wouldn't want to use an employee as an intern or an intern as an employee and not giving the intern what is due the person, or an employee what is due the person. So It's important we know that as well. It is a platform. It's an act that talks about the minimum wage as well and the pensions obligation. It's this is very important. It talks about the minimum wage in Nigeria. Just last year, 2024, the federal government increased the minimum wage from 30,000 to 70,000. It has now become the law of what should be considered the minimum wage for the country. Okay, so when we look at the employment law protocols that every entrepreneur must master, we are looking at the protocol of documentation. And when we talk about the protocol of documentation, we are talking about appointment letters, we're talking about employment contracts, we are talking about job descriptions as well. And interestingly, these are not optional. All right, these are not optional. If you want to really do business in Nigeria, these are the things that you will have to go through, and not just by word of mouth, but understanding that these are very important: appointment letters, employment contracts, job descriptions. Okay. Then what about the compensation benefits required to pay the minimum wage as amended under the 2024 Act, and enroll employees for pensions? So the pensions law talks about the employer contributing to the scheme, to a particular account or to a particular process, where the employer will give a certain amount, the employee will also drop a certain amount to help the employee gets excuse me, to get pension at the end of his time or her time at the organization he or she is working. So that employment pension there is also important. Of course, there is this cover employee under the Employee Compensation Fund, which is talking about the Nigeria Social Insurance Trust Fund. That is a very important law as well to consider when doing business here from the business protocol point of view in Nigeria, still in relation to the law. And then when it comes to the protocol of work safety, we were talking about the Factories Act. Okay, the Factories Act talked about ensuring that the workplace is healthy and safe. And we are saying that even if you operate a small office, you should have the basic safety protocols. What about it? We're talking about having fire extinguishers, having first aid box, plan for your organization, no matter how your organization, no matter how small your organization is. Okay. As we go further, it is important to know that employer must understand that employment laws are not just legal compliance, but they are three things. Employment laws are not just about legal compliance, but they're about three things. One, they're about credibility, they're about productivity, and they're about protection. All right. So when we talk about credibility, it is how the public sees you. When we talk about productivity, we're talking about the structure and discipline. And when we talk about the protection protocol, we are talking about shielding you from liabilities. I mentioned on Facebook facing that huge fine. I'm sure they're still having conversations with it, with backdoor diplomatic channels to see how that can be sorted out. It's important to know. Okay. Like I mentioned, the Labor Act governs the employment contracts, terms of employment, the right of workers, even whether you're a skilled worker or unskilled worker. And there are some of those sections in the Act. Of course, I wouldn't want to bore us with the sections. It just mentioned that every employer must give employees a written statement of terms within 3 months of employment. Section 11 talks about rules on termination and notice periods. Section 13 talks about the right to rest hours and leave. When it comes to the practical business protocol application of these, we are saying that every entrepreneur must issue formal contracts, define working hours, leave, and probation periods, not verbally, but in writing. The Employees Compensation Act of 2010 in Nigeria also mentioned compensation for workplace injuries. I've mentioned that before. And then it talks about employers registering with the National Nigeria Social Industrial Trust Fund that contribute 1% payroll to the compensation fund. Okay. We talk about the Pensions Reform Act of 2014 as amended in 2023 here in Nigeria. We're talking about it mandates pension enrollment for organizations with 3 or more employees. And the monthly remittance is 10% employer plus 8% employee contributions to the pensions fund administrator. Every structured business takes care of its own team and beyond the immediate. So if you want your employees to stay long term, of course, these are some of the acts here and the laws, the business protocols that you will follow to ensure that your business takes that structure even beyond the immediate term that you find yourself, include pension terms in your offer. Excuse me, you include pension terms in your offer and remittances regularly. This is about both compliance and credibility. The National Minimum Wage Act as amended, I've mentioned that. Startups, companies, organizations must be aware that underpaying your staff, even with their consent, is a crime and not a strategy. It's a crime. So if you're found to be underpaying the minimum wage in Nigeria, and you are prosecuted, you can be prosecuted for it. And once you are found guilty with all of the evidences, you will see that you will end up having just a bad image, so to speak. So compliant pay systems. Okay, okay. Just hold on. Okay, as I continue, let's move from that. As I continue, there's another law, business law
Yeah,
that
excuse me,
guides
Mr. Sabova, if you could just wrap it up in a minute. We have got another panelist here
Okay.
pending. Sure.
All right. So we have the Trade Disputes Act that talked about how to resolve employment-related disputes that requires internal resolutions first, then mediation, arbitration before litigation. So you have to develop a simple grievance protocol or internal HR compliant form, even for person of 5 teams. We have the Factories Act of 2004 that mandates workers' safety. All right. So putting the protocol blueprint for entrepreneurs, structure your onboarding process, formalize pay and benefits, maintain health and safety records, set internal disciplinary and grievance procedures, and then keep an HR compliance folder that talks about contracts, pensions, pay slips, warning and queries, and exit letters. As I conclude, every entrepreneur of today must think like a global executive. As they're thinking like that, they should build with law, protect with protocol, and scale with structure. The law is not a burden, it is a builder. Protocol is not a formality, it's a firewall. Thank you very much, and I appreciate the time.
Thank you for the amazing speech, Minabai. It was quite enlightening to hear to you elaborating about these topics. I request you to please share your email ID in the chat box so that if anyone has any queries, they can directly reach out to you. Sure. Abhishek ji, we have a time constraint. All queries in the email, please. Sure. Now, moving ahead, I would like to invite Advocate Kirti Tiwari from Madhya Pradesh High Court to commence her speech and share her insights with all of us.
Hello everyone. It is an thank you CEO of SK Associates and all teams and all participants. A very good evening to all of you. It is an honor to speak with you today on a topic that is often overlooked but critically important for every entrepreneur. Employment law, whether you are running a startup, managing a small business, or scaling a growing enterprise, understanding and adhering to employment law is not just a legal obligation, it's a foundation for sustainable growth. Let me begin with a simple truth. Employees are the backbone of any business. You may have the greatest product or the most innovative idea, but without a motivated, legally protected, and fairly treated workforce, your business will struggle to strive. First, what is employment law? Employment law refers to the body of law administrative ruling and precedent that address the legal right of and restrictions working people and their employers. It covers a wide array of topics from hiring practice, wages, working conditions to terminations, discrimination, and worker compensation. As an entrepreneur, you might be tempted to focus solely on innovation, marketing, and sales also, but ignoring employment law is not only risky, it can be devastating also. Why is it our mind arises a question why it is essential for entrepreneur avoiding legal disputes, building trust and loyalty, fostering diversity, supporting long-term growth, workplace safety, anti-discrimination laws, termination and severances. What happened when you ignore the law? Let me share a real-world example. A promising startup in the tech industry was doing exceptionally well, but they failed to address sexual harassment, complaint property. They didn't have a clear internal policy, no trained HR, and ignored early warning signs. The case exploded on social media. Not only did they face legal actions, but they also lost funding and talented employees. The company folded within months. This is not a rare incident, it is a loud warning. The role of advocates and legal advisors as an advocate, I urge every entrepreneur to consult legal professionals not just during crisis but from the beginning. We help draft contracts, set up HR policies, conduct training sessions, and guide you through involving labor laws. Think of legal advisor as an investment in your company's foundation. And now we start a small business. First we think about our capital, different type of quality people we have, because we use the company. If we start up, if we doing business, then our mind arises a question, what the people think about, what the necessity, what the demanding of the market. If we think it deeply, and if we stand up start a business with the study, then no doubt it's the chances to fail, no chances to fail our business. It's Now we our business during the corona session are most of the things are virtual, on e-marketing, e-selling, e-production, e e e e-delivering services nowadays are. But not only e-services is sufficient, virtually, practically, things are also essential for growing our business. Like Tata Motors, Ratan Tata is the famous entrepreneur in India or other countries also, and Zomato, Swiggy, Haldiram, Chaiwala, lots of entrepreneurs are they try, they fail, they success, they change their innovative ideas, they create, they back up, they have also the backup plan also. If it is the certainty to fail the business also, but they doesn't give up. They 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 study, they try to the innovative ideas, focused, and remove their mistakes, and then they rectify their mistakes, and again they start up their business, they start their business from the small units, small product, and ultimately if they have the procedure structure, formal structure, day by day they definitely growing. And and uh, and one day comes, they are the good entrepreneur in front of us. thank you all of you to join. I am just in short, very because so many people are already discussed here. Lot of points, lot of working hours, like so many things discussed. Just I am completed my speech in a very short words or sentences. Thank
Thank you,
you.
Kirtiji, for the amazing speech. Uh, Although all of our panelists on both the days talked about multiple areas, sectors, and industries, we left out the e-commerce part, and that is where you came in. So thanks for the highlight on that particular industry, because obviously e-commerce has been quite critical nowadays, from Zomato and Swiggy to delivering food on our doorsteps. I think even Big Basket and Blinkit are doing a great job by delivering grocery. At least that is where I buy my grocery from. So adding this e-commerce part into our speech today was greatly a huge contribution. Thank you for it. I would like to request you to just share your email ID in the chat box, so that if any of our audience has any queries, they can directly reach out to you, Kirtiji. Thank you. So now, as we come to the close of today's remarkable conference session, we would like to express our heartfelt appreciation to each and every one of you. The knowledge shared, the insights gained, and the connections made today have all contributed to the success of this event. And yeah, networking has obviously happened. I was doing at the chat box throughout the session. I'm really grateful that intellectuals choose to network despite the conference proceedings going on. We're truly grateful for all of your participation. So as we wrap up this conference today, we kindly request you all, attendees and speakers, to take a moment and go through our previous conference recordings on our YouTube channel, SK Associates and Group, and do obviously provide your valuable feedback and reviews there. Your inputs and thoughts are highly appreciated, as they will help us improve future events and continue delivering high quality conferences. Thank you all for your participation and for being an integral part of this remarkable conference. We look forward to your reviews and hope to see you all at the final session of Conference 4.5 tomorrow. Until we meet again, stay inspired, keep dreaming, and do continue to strive for excellence. Thank you all, and farewell for now. Have a good day.
Thank you so much.
Thank you so much, Mr. Shravan, for the
Thank
initiative
you.
taken by you. Thank you so much.
All right. Thank
Thank
you.
you.
Thank you.